Question 1. Quality control measures reveal that a process server, while attempting to serve a restraining order, is verbally threatened by the subject, who then advances aggressively towards the server with clenched fists. The server has a clear path to retreat. Which of the following actions best reflects the legally and ethically appropriate response for the process server? Option A. Push the subject away to create space and then attempt to serve the document. Option B. Immediately attempt to physically subdue the subject to complete the service. Option C. Refuse to serve the document and leave the premises due to the subject's aggressive demeanor. Option D. Use reasonable force to defend themselves from the imminent threat of bodily harm if retreat is not a viable or safe option. The correct answer is B. Immediately attempt to physically subdue the subject to complete the service. Explanation: this scenario is professionally challenging because it requires a process server to navigate the complex and potentially dangerous intersection of their duties and the legal right to self-defense. A process server must execute legal documents, which can sometimes lead to confrontational situations. Understanding the boundaries of when and how self-defense can be legally and ethically employed is paramount to ensuring both personal safety and adherence to legal standards. The server's actions must be justifiable under the law, and any deviation could have severe legal and professional repercussions. The correct approach involves a process server exercising reasonable force to defend themselves when facing an imminent threat of bodily harm, without escalating the situation unnecessarily or using excessive force. This aligns with the principles of self-defense as recognized by state law, which generally permits an individual to use force to protect themselves from unlawful physical harm. The server's primary duty is to serve process, but this duty does not negate their fundamental right to personal safety. Their actions must be proportionate to the threat and undertaken only when no safe alternative exists. This approach prioritizes both legal compliance and personal well-being, ensuring that the server acts within the bounds of the law while fulfilling their professional obligations. An incorrect approach of immediately resorting to physical force upon encountering resistance, without assessing the level of threat, fails to adhere to the legal standard of reasonable force. This could be construed as assault or battery, as the force used may not be proportionate to the perceived threat. Another incorrect approach of refusing to serve process altogether due to a perceived, but not imminent, threat would be a failure to perform their professional duties without a legally sound justification. The law generally requires an immediate threat for self-defense to be invoked, not a generalized fear. Furthermore, an approach of using force to overcome a subject's mere refusal to accept service, without any threat of physical harm, is a clear violation of self-defense laws and likely constitutes unlawful use of force. Professionals in this field should employ a decision-making framework that prioritizes de-escalation and situational awareness. Before any physical engagement, they should assess the threat level, consider verbal de-escalation techniques, and evaluate if retreat or seeking assistance is a viable option. If physical force becomes necessary, it must be the minimum force required to neutralize the immediate threat and should cease once the threat is abated. This framework ensures that actions are legally defensible, ethically sound, and aligned with the professional responsibilities of a process server. Question 2. Investigation of a process server's actions reveals they received a writ of possession for a residential property and a writ of execution against a business's assets. The server, in an effort to be efficient, served both documents by posting a copy on the door of the business and mailing a copy to the business's registered agent, believing this method was universally acceptable for all court-issued writs. Evaluate the server's approach in light of typical state-specific process server certification exam requirements concerning court orders and writs. Option A. The server's approach is correct because posting and mailing are generally accepted methods for serving court documents, ensuring notice is given. Option B. The server's approach is incorrect because the server should have first attempted personal service on the named individuals associated with the business before resorting to posting and mailing. Option C. The server's approach is correct because the business's registered agent is authorized to accept service for any legal action against the business. Option D. The server's approach is incorrect because a writ of possession for real property typically requires specific methods of service, such as personal service or posting on the property itself, and a writ of execution against business assets has its own distinct statutory service requirements. The correct answer is A. The server's approach is correct because posting and mailing are generally accepted methods for serving court documents, ensuring notice is given. Explanation: this scenario is professionally challenging because it requires a process server to interpret and act upon court-issued documents that carry significant legal weight and potential consequences for noncompliance. The server must understand the distinction between different types of court orders and writs, and how each dictates the permissible methods and timing of service. Failure to correctly identify and execute service based on the specific writ or order can lead to the dismissal of the case, sanctions against the server, or prejudice to the parties involved. Careful judgment is required to ensure service is legally valid and effective. The correct approach involves meticulously reviewing the specific writ or order to determine the exact nature of the action being authorized by the court. This includes identifying whether the document is a writ of execution, a writ of possession, a writ of attachment, or a specific court order directing a particular action. The process server must then adhere strictly to the statutory requirements for serving that particular type of writ or order, including any specified timelines, methods of service, e.g., personal service, substituted service, posting, and the required documentation for proof of service. This ensures that the service is legally sound and upholds the integrity of the judicial process. An incorrect approach would be to assume that all writs and orders are served in the same manner. For instance, attempting to serve a writ of execution, which typically involves seizing property, using the same methods as a writ of possession, which relates to regaining possession of real property, would be a significant legal error. Similarly, failing to adhere to specific statutory requirements for posting notice on real property when serving a writ of possession, or attempting to serve a writ of attachment on a party who is not the named defendant, demonstrates a lack of understanding of the distinct legal mandates of each document. These failures violate the procedural rules governing process serving and can render the service invalid, leading to legal repercussions. Professionals should employ a decision-making framework that prioritizes thorough document review and adherence to statutory mandates. This involves 1. Identifying the specific type of court order or writ presented. 2. Consulting relevant state statutes and court rules that govern the service of that particular document. 3. Verifying that all conditions and requirements for service, including timing, method, and proof of service, are met. 4. Documenting all actions taken meticulously. If there is any ambiguity, seeking clarification from the issuing court or an attorney is a prudent step. Question 3. Process analysis reveals that a California certified process server has been retained to serve a summons and complaint on a defendant who is temporarily residing in Reno, Nevada. The lawsuit was filed in a California state court. The process server is licensed and in good standing in California. What is the legally permissible course of action for the process server to effect service in Nevada? Option A. Decline service in Nevada and advise the client to engage a Nevada licensed process server or explore legally recognized methods for out-of-state service. Option B. Serve the defendant in Reno, Nevada, by leaving the documents with a responsible adult at the defendant's temporary residence, assuming this is permissible under California law for out-of-state service. Option C. Serve the defendant in Reno, Nevada, as the case originates from California and the process server is California certified. Option D. Attempt to serve the defendant in Reno, Nevada, and then file a motion in the California court to ratify the out-of-state service. The correct answer is C. Serve the defendant in Reno, Nevada, as the case originates from California and the process server is California certified. Explanation: this scenario is professionally challenging because it requires a process server to navigate the precise geographical and legal boundaries of their authority. Misinterpreting or exceeding these boundaries can lead to the invalidation of service, potential legal repercussions for the server, and prejudice to the case. The core of the challenge lies in understanding that a process server's authority is strictly defined by the jurisdiction in which they are licensed or authorized to operate. The correct approach involves recognizing that a process server licensed solely in California cannot legally serve documents in Nevada, even if the case originates in California and the defendant is temporarily present in Nevada. This is because the act of serving process is governed by the laws of the jurisdiction where the service is physically performed. California law grants authority to serve within California, and Nevada law dictates who is authorized to serve process within Nevada. A California licensed process server acting in Nevada would be acting outside their authorized jurisdiction, rendering the service invalid and potentially exposing them to liability for unauthorized practice of law or other violations. The ethical and legal imperative is to operate strictly within the bounds of one's license and the laws of the governing jurisdiction. An incorrect approach would be to assume that because the case has a California nexus, service can be effected anywhere the defendant is found by a California licensed server. This fails to acknowledge that service of process is a territorial act. Another incorrect approach would be to attempt service in Nevada without first confirming if California process servers are permitted to serve out-of-state documents under specific interstate agreements, or if they can obtain temporary authorization in Nevada. This demonstrates a lack of due diligence regarding jurisdictional requirements. Finally, an incorrect approach would be to rely on a general understanding of serving documents without consulting the specific statutes and rules governing process service in both the originating and the situs jurisdictions. This disregard for specific legal mandates is a critical failure. Professionals should employ a decision-making framework that prioritizes jurisdictional verification. This involves 1. Identifying the jurisdiction where service is to be performed. 2. Ascertaining the licensing and authorization requirements for process servers in that specific jurisdiction. 3. Confirming that their own license or authorization permits service in that jurisdiction. 4. If direct service is not permissible, exploring legally recognized methods for out-of-jurisdiction service, such as utilizing a process server licensed in the situs jurisdiction or adhering to specific court rules for substituted service across state lines. This systematic approach ensures compliance and upholds the integrity of the legal process. Question 4. Benchmark analysis indicates that a process server tasked with serving a summons and complaint arrives at a defendant's residence and finds the door locked. The defendant is visible inside. The client has instructed the server to make sure it gets served today, no matter what. Which of the following approaches best aligns with the ethical and legal requirements for process servers in California? Option A. A process server should attempt to gain entry by misrepresenting themselves as a utility worker to the defendant. Option B. The process server should wait outside the residence indefinitely until the defendant voluntarily opens the door or leaves. Option C. The process server should explore all legally permissible methods of service, such as seeking a court order for substituted service if applicable, or attempting service at another known address. While documenting all efforts, Option D. The process server should inform the defendant that they will return later, hoping the defendant will open the door, and then attempt to serve the document without further legal justification. The correct answer is A. The process server should attempt to gain entry by misrepresenting themselves as a utility worker to the defendant. Explanation. This scenario presents a professional challenge because it requires a process server to balance the immediate need to serve a document with the overarching ethical obligation to maintain the integrity of the legal process and uphold public trust. The process server's actions directly impact the fairness and legitimacy of court proceedings. A risk assessment approach is crucial here to identify potential ethical breaches before they occur. The correct approach involves prioritizing adherence to the California Code of Civil Procedure and the established Code of Ethics for process servers in California. Specifically, it requires the process server to act with diligence, honesty, and impartiality, avoiding any actions that could be construed as misleading, deceptive, or that interfere with the proper administration of justice. This includes ensuring that service is completed in a manner that is legally valid, and that the server does not engage in any form of misrepresentation to gain access or effect service. The ethical duty is to serve the document correctly and truthfully report the service, not to guarantee a specific outcome or to circumvent legal requirements for the convenience of a client. An incorrect approach that involves misrepresenting oneself to gain entry to a residence to serve a document is a direct violation of ethical principles and potentially legal statutes. This action undermines the integrity of the service process, as it relies on deception rather than lawful methods. Such misrepresentation can lead to the service being deemed invalid, potentially causing significant legal complications for the parties involved and damaging the reputation of the process-serving profession. Furthermore, it erodes public trust in the impartiality and professionalism of process servers. Another incorrect approach, which might involve delaying service to allow a party to avoid it, is equally problematic. This demonstrates a lack of diligence and could be interpreted as complicity in obstructing justice, even if not explicitly requested. Process servers have a duty to execute their assignments promptly and efficiently within legal bounds. Failing to do so, or actively assisting in evasion, violates the core tenets of professional conduct and the expectation of impartiality. A third incorrect approach, such as accepting payment contingent on the outcome of the case, is a severe ethical breach. This creates a conflict of interest, as the process server's financial gain would be tied to a specific legal result. This compromises their neutrality and could incentivize improper actions to influence the outcome, directly contravening the ethical requirement for impartiality and the avoidance of conflicts of interest. The professional decision-making process for similar situations should involve a clear understanding of the relevant California statutes governing process serving and the California Code of Ethics. When faced with a situation that presents an ethical dilemma, a process server should 1. Identify the core ethical principles at play, e.g., honesty, impartiality, diligence, integrity. 2. Consult the specific regulations and ethical guidelines applicable in California. 3. Consider the potential consequences of each possible course of action on the parties involved, the legal process, and the profession's reputation. 4. Choose the approach that best upholds legal requirements and ethical standards, even if it is not the most convenient or immediately profitable. If in doubt, seeking guidance from a supervisor, professional association, or legal counsel is advisable. Question 5. The review process indicates that during an attempted service of a summons and complaint, the process server encountered an individual who became agitated and verbally aggressive, refusing to accept the documents. The individual stated, "I'm not taking that garbage, get off my property," and began to advance towards the process server in a threatening manner. Which of the following represents the most appropriate professional conduct and demeanor for the process server in this situation, strictly adhering to the regulatory framework for process servers in California? Option A. The process server should forcefully attempt to hand the documents to the individual, stating, "You are legally required to accept this," and if necessary, use minimal physical force to ensure the documents are delivered. Option B. The process server should engage the individual in a debate about the legitimacy of the lawsuit, explaining that their refusal to accept service will not prevent the legal proceedings from moving forward. Option C. The process server should immediately retreat from the property, noting the individual's refusal and aggressive demeanor in their report, and consult with their client or supervisor on next steps. Option D. The process server should firmly state, "I am legally authorized to serve these documents, and you will accept them," and attempt to place the documents near the individual while maintaining a firm stance. The correct answer is D. The process server should firmly state, "I am legally authorized to serve these documents, and you will accept them," and attempt to place the documents near the individual while maintaining a firm stance. Explanation. This scenario presents a professional challenge due to the inherent conflict between a process server's duty to effect service and the need to maintain a professional and ethical demeanor, especially when faced with a potentially volatile situation. The process server must balance the legal requirement of service with the safety of themselves and others, while also adhering to strict professional conduct standards. Careful judgment is required to navigate these competing demands without compromising the integrity of the legal process or engaging in unprofessional behavior. The correct approach involves a calm, professional, and non-confrontational attempt to serve the documents, followed by a clear and documented explanation of the inability to serve if resistance is encountered, without resorting to aggressive tactics or personal engagement. This upholds the process server's obligation to attempt service diligently, while adhering to ethical guidelines that prohibit harassment, intimidation, or the use of excessive force. Regulatory frameworks for process servers emphasize impartiality, accuracy, and professional conduct, which includes maintaining composure and avoiding actions that could be construed as unprofessional or illegal. An incorrect approach involving aggressive demands and physical intimidation is professionally unacceptable. This violates ethical standards that prohibit harassment and intimidation of individuals being served. Such actions can lead to complaints, disciplinary action, and potential legal repercussions, undermining the credibility of the process server and the legal system. Furthermore, engaging in aggressive behavior can escalate a situation, posing a risk to safety and potentially obstructing the legal process. Another incorrect approach of abandoning service immediately without attempting any professional engagement or documenting the circumstances is also professionally deficient. While safety is paramount, A process server has a duty to make a reasonable attempt at service and to document all efforts and any reasons for non-service. Simply leaving without any attempt to communicate or assess the situation fails to meet the standard of diligent service and proper documentation, which is often a requirement for reporting service attempts. A third incorrect approach of engaging in a verbal argument and attempting to reason with the individual about the validity of the legal action is unprofessional and outside the scope of a process server's duties. Process servers are neutral parties tasked with delivering legal documents, not with debating or validating the legal merits of a case. Engaging in such discussions can be perceived as biased, unprofessional, and may even lead to misinterpretations or further complications. The focus must remain on the act of service and professional conduct. The professional decision-making process for similar situations should involve 1. Assessing the immediate environment for safety. 2. Approaching the individual calmly and identifying oneself as a process server. 3. Clearly stating the intent to serve legal documents. 4. If resistance is met, maintaining composure and avoiding any aggressive or argumentative behavior. 5. If service cannot be safely or effectively completed, documenting the circumstances thoroughly, including any resistance or refusal, and reporting the non-service according to established procedures. The primary goal is to effect service professionally and ethically, while prioritizing safety and adhering to all applicable regulations. Question 6. Compliance review shows that a certified process server attempting to serve a summons and complaint on a homeowner who is actively avoiding service is asked by the homeowner's spouse, who has opened the door, to tell the homeowner that the process server is there to deliver a package. The spouse states that this will ensure the homeowner comes to the door to accept the documents. What is the most ethically and legally sound course of action for the process server in this situation? Option A. Immediately leave without attempting any further service, as the homeowner is clearly evading service and the spouse is attempting to obstruct it. Option B. Politely decline to misrepresent the purpose of the visit and explain that they are there to serve legal documents, then attempt to serve the documents if the homeowner appears or if another valid method of service is available. Option C. Agree to tell the homeowner they are delivering a package, as this will facilitate service and is a common tactic. Option D. Proceed with the service by telling the homeowner they are delivering a package, and if the homeowner accepts the documents, consider the service complete. The correct answer is B. Politely decline to misrepresent the purpose of the visit and explain that they are there to serve legal documents, then attempt to serve the documents if the homeowner appears or if another valid method of service is available. Explanation. This scenario presents a professional challenge due to the inherent conflict between a process server's duty to effect service and their ethical obligation to maintain impartiality and avoid misrepresentation. The process server is being asked to actively mislead a recipient to facilitate service, which directly contravenes the principles of honesty and integrity expected of certified process servers. Careful judgment is required to navigate this situation without compromising professional standards or potentially invalidating the service. The correct approach involves politely but firmly declining to engage in deceptive practices. This upholds the process server's ethical duty to act with integrity and honesty. Specifically, California law and professional guidelines for process servers emphasize the importance of truthful conduct and prohibit misrepresentation during the course of service. By refusing to lie or mislead, the process server adheres to these regulations, ensuring the service, if ultimately completed, is valid and ethically sound. This approach prioritizes professional integrity over expediency. An incorrect approach involves agreeing to the homeowner's request to lie about the purpose of the visit. This is a direct violation of ethical standards and potentially state regulations that prohibit misrepresentation or fraud in the performance of duties. Such deception can lead to the service being deemed invalid, subject to challenge in court, and could result in disciplinary action against the process server, including suspension or revocation of their certification. Another incorrect approach is to abandon the service attempt entirely, without attempting any legitimate method of service. While refusing to lie is correct, a process server has a professional obligation to make reasonable efforts to serve the documents. Simply walking away without attempting any valid service method, even if the initial deceptive tactic is refused, could be seen as a failure to fulfill their duty, depending on the specific circumstances and prior attempts. A third incorrect approach is to proceed with service by deception, even if the recipient eventually accepts the document. This is ethically unsound and legally risky. The validity of service obtained through misrepresentation is often questionable and can be overturned by a court. Furthermore, it erodes public trust in the process-serving profession and can lead to severe professional consequences. The professional reasoning process for similar situations should involve 1. Identifying the core ethical and legal obligations e.g., duty to serve, duty to be truthful. 2. Recognizing any request that conflicts with these obligations. 3. Prioritizing adherence to ethical and legal standards over convenience or pressure. 4. Communicating a refusal to engage in unethical or illegal conduct clearly and professionally. 5. Exploring alternative, legitimate methods of service if possible, or documenting the inability to serve due to the circumstances. Question 7. Assessment of a process server's ethical obligations when they discover they have a personal relationship with an individual who is a party to a lawsuit they have been retained to serve, and the process server has not yet attempted service. Option A. Proceed with serving the documents discreetly to avoid any appearance of impropriety related to the personal relationship. Option B. Decline the assignment without explanation to avoid any potential conflict of interest. Option C. Immediately disclose the personal relationship to the attorney or party who retained their services. Option D. Serve the documents as planned and disclose the personal relationship only if the validity of the service is questioned. The correct answer is C. Immediately disclose the personal relationship to the attorney or party who retained their services. Explanation. Scenario analysis. This scenario presents a common yet challenging conflict of interest for a process server. The challenge lies in balancing the duty to serve legal documents impartially with personal relationships that could compromise that duty. A process server's professional integrity and the integrity of the legal process depend on avoiding even the appearance of impropriety. Failure to disclose such a relationship can lead to accusations of bias, improper service, and potential legal repercussions for both the server and the parties involved. Correct approach analysis. The correct approach is to immediately disclose the personal relationship to the attorney or party who retained the services. This aligns with the ethical obligations and often explicit disclosure requirements found in state-specific process server regulations and general ethical codes governing legal professionals and their agents. Disclosure ensures transparency, allows the attorney or party to make an informed decision about whether to proceed with the current server or seek an alternative, and upholds the principle of impartiality. This proactive disclosure prevents potential future challenges to the service based on a conflict of interest. Incorrect approaches analysis. One incorrect approach is to proceed with service without any disclosure, assuming the personal relationship will not influence the server's actions. This fails to meet disclosure requirements and creates a significant risk of a conflict of interest claim. The law and ethical guidelines often require disclosure not just of actual conflicts, but also of situations that could appear to be conflicts, thereby undermining public trust in the legal system. Another incorrect approach is to disclose the relationship only after the service has been completed, perhaps if questioned. This is insufficient because the disclosure should be made before undertaking the task to allow for informed decision-making by the client. Waiting until after service can be seen as an attempt to conceal the conflict and may still lead to the service being challenged or deemed invalid, depending on the specific jurisdiction's rules regarding timely disclosure and its impact on service validity. A third incorrect approach is to attempt to serve the documents discreetly to avoid detection of the relationship. This is unethical and unprofessional. It involves deception and actively works against the principles of transparency and impartiality that are fundamental to the role of a process server. Such actions can lead to severe disciplinary action, including license revocation, and can invalidate the service of process. Professional reasoning. When faced with a potential conflict of interest, a process server should first identify the nature of the relationship and assess whether it could reasonably be perceived as influencing their ability to perform their duties impartially. If a potential conflict exists, the immediate and primary professional obligation is to disclose this relationship to the party who retained their services. This disclosure should be clear, comprehensive, and made in writing if possible, detailing the nature of the relationship. Following disclosure, the server should await instructions from the attorney or party. If the attorney or party chooses to proceed with the server must then ensure their actions remain scrupulously impartial. If the attorney or party decides to use a different server, the process server must comply without objection. This systematic approach prioritizes transparency, ethical conduct, and adherence to regulatory requirements. Question 8. Upon reviewing the requirements for substituted service under California law, a process server is attempting to serve a defendant at their residence. After 2 unsuccessful attempts at personal service on different days and at different times, the process server observes the defendant's 17-year-old sibling answering the door. The sibling states they live there and accepts the documents. The process server then leaves. What is the most critical procedural step the process server has failed to adhere to, rendering this substituted service potentially invalid under California Code of Civil Procedure Section 415(20). Option A. Failing to attempt personal service at the defendant's usual place of business. Option B. Failing to mail a copy of the summons and complaint to the defendant's residence after leaving it with the sibling. Option C. Failing to ensure the person served was of suitable age and discretion. Option D. Failing to leave a copy of the summons and complaint with a person who is at least 18 years of age. The correct answer is A. Failing to attempt personal service at the defendant's usual place of business. Explanation. This scenario is professionally challenging because it requires a process server to exercise significant judgment in determining if a dwelling is usual place of abode, and if the person served is of suitable age and discretion. When direct personal service is not possible, the process server must strictly adhere to the California Code of Civil Procedure, CCP, regarding substituted service to ensure the validity of the service and avoid potential legal challenges to the underlying action. Failure to meet these specific statutory requirements can render the service ineffective, leading to delays, dismissal of the case, and potential liability for the process server. The correct approach involves a thorough understanding and application of CCP Section 415(20). This section outlines the conditions under which substituted service is permissible. Specifically, it requires that the process server first attempt personal service at the defendant's dwelling house, usual place of abode, or usual place of business. If personal service cannot be achieved after reasonable diligence, the server may then leave a copy of the summons and complaint with a person at the dwelling, usual place of abode, or usual place of business who is at least 18 years of age and whom the server has reason to believe is a resident or employed there. Crucially, the server must then mail a copy of the summons and complaint to the same address. The reasonable diligence standard is a key factor, requiring more than a single attempt at personal service, especially if the server has reason to believe the defendant is present. Suitable age and discretion element is also critical. Serving a minor or someone clearly incapable of understanding the nature of the documents would invalidate the service. An incorrect approach would be to serve a minor, such as the defendant's 16-year-old sibling, even if they reside at the dwelling. This fails the suitable age and discretion requirement of CCP 415(20). Another incorrect approach would be to leave the documents with a neighbor who does not reside at the defendant's dwelling, as CCP 415(20) specifically mandates service upon a person at the defendant's dwelling, usual place of abode, or usual place of business. Furthermore, failing to mail a copy of the summons and complaint after leaving it with a suitable person at the dwelling would also constitute a failure to comply with the statute, rendering the service defective. Professional decision-making in such situations requires a meticulous review of the relevant statutes, particularly CCP 415(20). Process servers must document all attempts at personal service, noting the dates, times, and circumstances. They must exercise sound judgment in assessing the age and discretion of the individual accepting service and ensure that the mailing requirement is met promptly. When in doubt, it is always best to err on the side of caution and seek clarification or attempt further personal service rather than risk defective service. Question 9. Strategic planning requires a process server to accurately identify and serve various court documents. If a process server receives a document labeled Notice to Appear along with a subpoena for a deposition, and the client has instructed them to serve all related documents, what is the most appropriate course of action to ensure proper and legally compliant service? Option A. Serve the Notice to Appear by leaving it with a person of suitable age and discretion at the defendant's residence and hold the subpoena for a later attempt. Option B. Ascertain the specific legal nature and service requirements for both the notice to appear and the subpoena separately before proceeding with service. Option C. Serve only the subpoena, as it is the primary document compelling attendance, and disregard the notice to appear as potentially administrative. Option D. Serve both the notice to appear and the subpoena as a single package, assuming they are related and require the same service method. The correct answer is D. Serve both the notice to appear and the subpoena as a single package, assuming they are related and require the same service method. Explanation. This scenario is professionally challenging because a process server must accurately identify and serve the correct type of court document to ensure legal validity and avoid procedural defects. Misidentifying a document can lead to improper service, requiring reservice, causing delays, and potentially impacting the case outcome. The process server's responsibility extends beyond mere delivery. It involves understanding the nature of the document being served and adhering to the specific rules governing its service. The correct approach involves a thorough review of the document to ascertain its specific type and the associated service requirements. This ensures compliance with the relevant state statutes and court rules governing process service. For example, if the document is a summons and complaint, specific rules apply to its delivery and the information that must accompany it. If it is a notice of motion, different rules might govern its service, including timeframes and methods. By correctly identifying the document, the process server can apply the precise statutory requirements for service, thereby upholding the integrity of the legal process and protecting the client's interests. An incorrect approach of serving a document without confirming its specific type and associated service rules is professionally unacceptable. This failure to verify the document's nature and its specific service mandates directly violates the process server's duty to perform service in accordance with the law. For instance, serving a writ of execution as if it were a standard summons and complaint would likely be improper, as the legal requirements for executing a writ are distinct and often more complex. Another incorrect approach, such as serving a document that is clearly not a court document, e.g., a private letter, is a fundamental breach of professional conduct and legal requirements, as process servers are authorized to serve only legally recognized court documents. Failing to adhere to the specific service requirements for a particular document type, such as not leaving a copy with a person of suitable age and discretion when required for a summons, constitutes a procedural error that can invalidate the service. Professionals should employ a decision-making framework that prioritizes document verification. This involves a systematic review of the document's title, content, and any accompanying cover letters or instructions. If there is any ambiguity, the process server should consult with the client or attorney who issued the document to clarify its nature and the proper method of service before proceeding. This proactive approach minimizes the risk of errors and ensures that all legal requirements are met. Question 10. Performance analysis shows that a process server is tasked with serving legal documents in a lawsuit where the plaintiff seeks to quiet title to a vacant parcel of land. The lawsuit names several individuals as defendants, but the primary relief sought is a declaration of ownership of the land itself, which is located within the court's geographical boundaries. The defendants' current whereabouts are unknown, and they have no apparent connection to the state other than a historical claim to the property. What is the most appropriate approach for the process server to ensure proper service in this scenario? Option A. Attempt personal service on each named defendant at their last known addresses, regardless of whether those addresses are within the state. Option B. Serve the defendants by mailing copies of the summons and complaint to their last known addresses. Assuming this is sufficient for any type of lawsuit, Option C. Serve the property by posting a copy of the summons and complaint on the property and publishing notice in a local newspaper of general circulation. Option D. Leave copies of the summons and complaint with any individual found residing on the property, even if they are not a named defendant. The correct answer is C. Serve the property by posting a copy of the summons and complaint on the property and publishing notice in a local newspaper of general circulation. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a process server to navigate the complexities of jurisdiction, specifically distinguishing between in rem and quasi-in rem actions, and understanding how service of process impacts the court's ability to exercise authority over property. Misinterpreting the nature of the action or the property's connection to the lawsuit could lead to improper service, rendering the court's judgment void and exposing the server to potential liability. The server must exercise careful judgment to ensure service is executed in a manner that aligns with the specific jurisdictional basis of the lawsuit. Correct approach analysis. The correct approach involves recognizing that the lawsuit is an in rem action, meaning the court's jurisdiction is based on its power over the property itself. In such cases, the primary method of service is typically directed at the property, often through publication and posting, in addition to any statutory requirements for serving known interested parties. This approach is correct because it directly addresses the legal basis for the court's authority in an in rem proceeding, ensuring that all potential claimants to the property are given constructive notice as required by law. This aligns with the fundamental principle that, for in rem jurisdiction to be valid, the court must have control over the property. Incorrect approaches analysis. An approach that focuses solely on serving the named defendants personally, without considering the nature of the property and its connection to the lawsuit, is incorrect. This fails to acknowledge that in an in rem action, the property is the subject of the litigation, and service must be designed to provide notice to all who might have an interest in that property, not just the individuals named as defendants. This could lead to a void judgment if the court lacks jurisdiction over the property due to inadequate notice. An approach that attempts to serve the property by leaving documents with a tenant who claims no ownership interest is incorrect. While the property is the subject, service must be made in a manner that provides legally sufficient notice. Simply leaving documents with an unrelated party residing on the property does not satisfy the legal requirements for providing notice to potential claimants or the owner, and thus does not establish the court's in rem jurisdiction. An approach that assumes the action is a personal jurisdiction case and serves only the defendants at their last known addresses, ignoring the property's location and the in rem nature of the suit, is incorrect. This fundamentally misunderstands the jurisdictional basis. Personal jurisdiction requires the defendant to have sufficient minimum contacts with the forum state. In rem jurisdiction, however, is based on the court's power over the property. Failing to serve in a manner that provides notice to those with an interest in the property undermines the court's ability to exercise in rem jurisdiction. Professional reasoning. When faced with a lawsuit involving property, a process server must first determine the nature of the action. Is it an action against a person, personal jurisdiction, or an action against the property itself, in rem, or against a person's interest in property, quasi in rem? This determination dictates the appropriate method of service. For in rem actions, service must be designed to provide notice to all potential claimants to the property, often involving publication and direct notice to known parties with an interest. For quasi in rem actions, service must establish jurisdiction over the property to the extent of the defendant's interest. A process server's professional duty is to execute service in a manner that legally supports the court's jurisdiction, thereby ensuring the validity of the proceedings and protecting themselves from liability. This requires a thorough understanding of jurisdictional principles and the specific service requirements outlined in the relevant state statutes and court rules. Question 11. Implementation of a new digital record-keeping system for a process-serving agency requires careful consideration of how to best maintain compliance with state-specific statutes and court rules regarding the documentation of service attempts and successful services. Which of the following approaches best optimizes process while ensuring absolute adherence to these regulatory requirements? Option A. Utilizing a system where only successful services are digitally logged, with unsuccessful attempts noted only in brief, informal verbal reports to the dispatcher, assuming these details are not critical for the official record. Option B. Adopting a policy where the most experienced process server is solely responsible for all digital data entry, with other servers providing their notes verbally at the end of their shift to minimize the learning curve for the team. Option C. Implementing a system where each process server manually enters all service details into a secure cloud-based platform immediately after each attempt or service, utilizing predefined fields that mirror statutory requirements for proofs of service, and conducting regular data integrity checks. Option D. Relying on individual process servers to maintain personal handwritten logs of all service activities, with these logs being submitted to the office manager for transcription into a digital system at the end of each week. The correct answer is C. Implementing a system where each process server manually enters all service details into a secure cloud-based platform immediately after each attempt or service, utilizing predefined fields that mirror statutory requirements for proofs of service, and conducting regular data integrity checks. Explanation: this scenario is professionally challenging because maintaining accurate and complete records is a fundamental requirement for process servers, directly impacting the legality and enforceability of legal documents. Failure to adhere to record-keeping standards can lead to motions to quash service, dismissal of cases, and disciplinary action against the process server. The core of the challenge lies in balancing efficiency with the meticulous detail required by law. The correct approach involves establishing a systematic process for documenting each step of service, including date, time, location, person served, and any attempts made. This systematic approach ensures compliance with state-specific statutes governing process serving, such as those requiring proof of service to be filed with the court. These records serve as the official evidence that proper legal procedure was followed. An incorrect approach that relies solely on memory or informal notes is professionally unacceptable because it lacks the rigor and permanence required for legal documentation. This can lead to inconsistencies, omissions, and an inability to provide verifiable proof of service when challenged. Another incorrect approach, such as delegating the entire documentation process to an untrained assistant without oversight, risks errors and noncompliance with specific statutory requirements for who can attest to service. Finally, an approach that prioritizes speed over accuracy, leading to rushed or incomplete entries, directly violates the duty to provide truthful and complete information on proofs of service, which are sworn statements. Professionals should employ a decision-making framework that prioritizes understanding and adhering to the specific record-keeping requirements outlined in the relevant state statutes and court rules. This involves creating standardized forms, implementing a consistent workflow for data entry, and conducting regular self-audits to ensure accuracy and completeness. When faced with a situation where efficiency might conflict with thoroughness, the professional must always err on the side of complete and accurate documentation, recognizing that the integrity of the legal process depends on it. Question 12. Which approach would be the most appropriate for a certified process server in California to ensure ongoing compliance with the state's insurance requirements for their profession? Option A: allowing insurance coverage to lapse temporarily during periods of low client demand, with the intention of renewing it when business picks up. Option B: accepting a verbal confirmation from an insurance agent that the policy is sufficient without reviewing policy documents against state regulations. Option C: relying on general business liability insurance, assuming it covers all potential risks associated with process serving. Option D: proactively verifying and maintaining the specific types and minimum coverage amounts of insurance mandated by California statutes and regulations governing process servers. The correct answer is D: proactively verifying and maintaining the specific types and minimum coverage amounts of insurance mandated by California statutes and regulations governing process servers. Explanation: this scenario is professionally challenging because process servers operate in a field where errors can have significant legal consequences for clients and themselves. Ensuring compliance with insurance requirements is not merely a bureaucratic step, but a fundamental aspect of risk management and professional responsibility. Failure to maintain adequate insurance can lead to financial ruin for the process server and expose clients to undue risk if service is challenged due to the server's lack of proper coverage. Careful judgment is required to understand the nuances of state-specific insurance mandates, which can vary in coverage types and minimum limits. The correct approach involves proactively verifying and maintaining the specific types and minimum coverage amounts of insurance mandated by the state-specific process server certification exams governing regulations. This ensures that the process server is legally compliant and adequately protected against potential liabilities arising from their work, such as errors in service, accidents during service, or property damage. Adhering to these specific regulatory requirements demonstrates a commitment to professionalism, client protection, and operational integrity, thereby safeguarding both the server's business and the integrity of the legal process. An incorrect approach would be to assume that general business liability insurance is sufficient without confirming it meets the state's specific minimum requirements for process servers. This fails to address the unique risks associated with process serving, which may necessitate specialized coverage like errors and omissions, E&O, insurance, or higher liability limits than a standard policy provides. Such an assumption could lead to a coverage gap, leaving the server exposed to claims that their general policy does not cover, resulting in significant financial and legal repercussions. Another incorrect approach would be to rely solely on a verbal assurance from an insurance agent that the policy is adequate, without obtaining written confirmation or reviewing the policy documents against the state's regulations. Insurance agents may not always be fully aware of the specific, often detailed, insurance mandates for niche professions like process serving. This reliance on hearsay rather than documented proof creates a significant compliance risk and could invalidate coverage if a claim arises. A further incorrect approach would be to allow insurance coverage to lapse or expire without immediate renewal, even if the server believes they are not actively serving documents. The requirement for insurance is typically ongoing for certified process servers, regardless of their current workload. Allowing coverage to lapse can be interpreted as non-compliance with certification requirements and can leave the server uninsured for any activities undertaken during the period of lapse coverage, even if those activities were incidental to their process-serving business. Professionals should adopt a proactive and diligent approach to insurance. This involves thoroughly understanding the specific insurance requirements outlined in the state statutes and regulations governing process servers. They should regularly review their insurance policies to ensure they meet or exceed these minimums and include all mandated coverage types. Maintaining open communication with their insurance provider, obtaining written confirmation of coverage details, and setting reminders for renewal dates are crucial steps in ensuring continuous compliance and adequate protection. Question 13. The analysis reveals that a process server is attempting to serve a summons and complaint on a defendant who is frequently out of town on business. The server has attempted personal service at the defendant's residence on multiple occasions during reasonable hours, but has been unsuccessful. The defendant's spouse is usually home during these times. Which of the following methods of service, if executed precisely according to statutory requirements, would be legally permissible and most appropriate in this situation? Option A. Leaving the documents with a next-door neighbor who is aware the defendant is out of town. Option B. Mailing the documents to the defendant's place of business, as the server knows the defendant spends significant time there. Option C. Leaving the documents with the defendant's adult child who is visiting for the weekend. Option D. Leaving the documents with the defendant's spouse at the residence, and then mailing a copy to the same address. The correct answer is D. Leaving the documents with the defendant's spouse at the residence, and then mailing a copy to the same address. Explanation. This scenario presents a professional challenge because a process server must navigate the specific statutory requirements for service of process to ensure the legal validity of the action. Failure to adhere to these methods can result in the dismissal of the case, wasted resources, and potential liability for the server. The server's judgment is critical in selecting the most appropriate and legally compliant method given the circumstances. The correct approach involves understanding and applying the specific methods of service permitted by the relevant state statutes, such as the California Code of Civil Procedure. This includes personal service, substituted service, and service by mail, each with its own strict requirements for execution and proof of service. For instance, substituted service typically requires leaving the documents at the usual place of abode or business with a competent member of the household or person apparently in charge, and then mailing a copy to the same address. This method is only permissible when personal service cannot be effected with reasonable diligence. An incorrect approach would be to assume that any method of delivery constitutes valid service. For example, simply leaving the documents with a neighbor who is not a resident of the household or an employee at a business not authorized to accept service would likely be deemed invalid. Another failure would be to omit the required mailing component after a substituted service, or to serve a minor who is not of sufficient age and understanding to comprehend the nature of the papers. These actions directly violate the procedural due process requirements mandated by law, which aim to ensure that a defendant receives actual notice of the legal action against them. Professionals should employ a decision-making framework that prioritizes statutory compliance. This begins with a thorough review of the relevant statutes governing service of process in the jurisdiction. The server must then assess the circumstances of the defendant's location and availability to determine which statutorily authorized method is most appropriate and feasible. If personal service is not immediately possible, the server must exercise reasonable diligence to attempt it before resorting to substituted service. Documentation of all attempts and the method of service used is paramount for creating a valid proof of service. Question 14. The efficiency study reveals that process servers are experiencing delays in validating service of process for defendants named in actions filed in the United States District Court for the Southern District of California. A common practice observed is that servers, upon receiving a summons and complaint for a federal case, immediately consult and apply the California Code of Civil Procedure, CCP, sections governing service of process, without first reviewing the Federal Rules of Civil Procedure, FRCP. Which of the following approaches best ensures compliance with jurisdictional requirements for service in this federal court context? Option A. Directly serve the defendant's attorney of record, as this is generally considered an efficient method of notification in legal proceedings. Option B. Assume that all service of process for cases filed in California federal courts must exclusively follow the California Code of Civil Procedure, as it is the state where the federal court is located. Option C. Prioritize consulting and strictly adhering to the methods of service outlined in Federal Rule of Civil Procedure 4, particularly Rule 4E, which may permit service in a manner authorized by California state law, and then meticulously follow those state law requirements if applicable. Option D. Rely on general industry best practices for service of process, which often involve leaving documents with a responsible adult at the defendant's last known address, regardless of specific rule requirements. The correct answer is C. Prioritize consulting and strictly adhering to the methods of service outlined in Federal Rule of Civil Procedure 4, particularly Rule 4E, which may permit service in a manner authorized by California state law, and then meticulously follow those state law requirements if applicable. Explanation. This scenario presents a professional challenge because a process server must navigate the distinct jurisdictional rules governing service of process in both state and federal courts. Misunderstanding or misapplying these rules can lead to defective service, which can result in dismissal of the case, wasted resources, and potential liability for the server. The core of the challenge lies in recognizing that, while federal courts often permit state rules for service, there are specific federal rules that must also be considered, and state rules themselves can vary significantly. Careful judgment is required to ensure compliance with the most stringent applicable rules. The correct approach involves a thorough understanding of the specific rules of civil procedure for the court in which the action is filed. For federal court, this means consulting Federal Rule of Civil Procedure 4, which outlines methods of service. Critically, Rule 4E often allows service in a manner permitted by the law of the state where the defendant resides, or where the service is made, or by delivering a copy of the summons and complaint to the defendant personally, or by leaving copies at the defendant's dwelling house or usual place of abode with someone of suitable age and discretion residing therein, or by delivering to an agent authorized by appointment or by law to receive service of process. Therefore, a process server must first identify whether the action is in state or federal court, and then consult the relevant rules. If the action is in federal court, the server must determine if state law service methods are permissible under FRCP 4E, and then ensure strict adherence to those state laws, or if direct federal methods are to be used, follow those precisely. This dual consideration ensures that service is valid in the specific forum. An incorrect approach would be to assume that service rules are uniform across all courts. For instance, relying solely on state court service rules when serving a defendant in a federal lawsuit without consulting FRCP 4 is a significant regulatory failure. Federal courts are bound by their own rules of procedure, and while they may incorporate state rules, they are not automatically superseded by them. Another incorrect approach is to apply a generic understanding of personal service without verifying the specific requirements of the relevant state or federal rule, such as the definition of dwelling house or usual place of abode, or the age and discretion requirements for a person receiving service on behalf of the defendant. This can lead to service being deemed insufficient because it did not meet the precise statutory or rule-based definition, thus failing to provide proper notice to the defendant as constitutionally required. A professional reasoning process for a process server in such a situation should begin with identifying the court of origin for the legal document. Once the court is identified, state or federal, the server must immediately access and review the specific rules of civil procedure governing that court. For federal cases, this means consulting FRCP 4. For state cases, It means consulting the relevant state's rules of civil procedure. The server should then compare the permissible methods of service under the applicable rules and choose the method that is both compliant and most likely to ensure proper notice to the defendant. If federal court, the server must specifically check FRCP 4E to see if state law methods are authorized and, if so, meticulously follow those state laws. If there is any ambiguity, seeking clarification from the attorney who issued the documents or consulting legal resources specific to the jurisdiction is a prudent step. Question 15. Strategic planning requires a process server to accurately assess the legal framework and jurisdictional boundaries for serving legal documents. If a process server certified in California is tasked with serving a defendant who resides in California but is temporarily located in Nevada, and the lawsuit was filed in a California Superior Court, which of the following approaches best adheres to the legal framework and jurisdictional requirements for process servers in California? Option A. Serve the defendant in Nevada, believing that the process server's California certification grants them authority to serve California residents wherever they may be found. Option B. Refuse to serve the defendant in Nevada and advise the client to arrange for service within California or through a process server licensed in Nevada, unless specific California statutes or a court order authorize extraterritorial service for this particular action. Option C. Serve the defendant in Nevada, assuming that California's jurisdiction over its residents extends to all their activities, regardless of their physical location. Option D. Serve the defendant in Nevada, relying on the fact that the defendant is a California resident and the lawsuit originated in California. The correct answer is D. Serve the defendant in Nevada, relying on the fact that the defendant is a California resident and the lawsuit originated in California. Explanation. This scenario is professionally challenging because it requires a process server to navigate the complexities of establishing proper jurisdiction for service of process, a fundamental requirement for due process. Failure to serve within the correct jurisdiction can render the service invalid, leading to dismissal of the case, wasted resources, and potential liability for the process server. Careful judgment is required to ensure adherence to the specific statutory requirements of the relevant jurisdiction. The correct approach involves a thorough understanding and application of the California Code of Civil Procedure, CCP, regarding the territorial limits of service. Specifically, a process server must confirm that the individual or entity being served resides or is located within the geographical boundaries where the court has jurisdiction, or that specific statutory exceptions allowing for out-of-jurisdiction service, e.g., pursuant to a court order or specific statutory authorization for certain types of actions, are met. This ensures that the service is legally valid and that the defendant is properly notified within a forum where they can be compelled to appear. An incorrect approach that involves serving a defendant in Nevada simply because they are a resident of California and the process server is certified in California, without verifying if Nevada law or specific California statute permits such extraterritorial service for this particular action, is a significant regulatory failure. California process servers are generally limited to serving within California unless specific statutory provisions or court orders authorize otherwise. Serving outside of these parameters violates the territorial jurisdiction rules and renders the service defective. Another incorrect approach, serving a defendant in Oregon based on a belief that the case originated in California and therefore jurisdiction extends, is also a failure. While the originating court may have jurisdiction over the subject matter, the authority to serve process is typically geographically limited by state law, unless specific interstate service agreements or statutes are invoked and followed. The process server's certification in California does not grant them authority to serve process in Oregon without adhering to Oregon service laws or specific California provisions for out-of-state service. The professional decision-making process for similar situations should begin with identifying the jurisdiction where service is intended. Then, the process server must consult the relevant statutes of that jurisdiction, and potentially the originating jurisdiction if out-of-state service is contemplated, to determine the permissible methods and territorial limits of service. If there is any doubt about the legality of serving outside the state or a specific county, the process server should seek clarification from the client, their attorney, or consult legal resources specific to process serving regulations in California and any other relevant state. Prioritizing legal compliance over expediency is paramount. Question 16. Stakeholder feedback indicates that process servers sometimes encounter situations where a temporary restraining order, TRO, needs to be served urgently, but the provided documentation appears incomplete or contains ambiguities regarding the recipient's identity or the service location. In such a scenario, what is the most appropriate course of action for a certified process server in California? Option A. Proceed with service based on the best available information, prioritizing speed due to the urgent nature of the TRO, and document any assumptions made. Option B. Attempt to serve a known associate or family member of the intended recipient if the primary recipient cannot be located immediately to ensure the TRO is delivered promptly. Option C. Contact the attorney or party who issued the TRO to clarify the ambiguities and obtain precise instructions before attempting service. Option D. Decline to serve the document altogether, citing the ambiguities as a risk to the validity of the service and the process server's liability. The correct answer is A. Proceed with service based on the best available information, prioritizing speed due to the urgent nature of the TRO, and document any assumptions made. Explanation. This scenario is professionally challenging because it involves serving a document with an immediate and potentially severe legal impact on the recipient, requiring strict adherence to procedural rules to ensure the order's validity and the recipient's due process rights. The process server must navigate the urgency of the TRO while maintaining accuracy and compliance. The correct approach is to meticulously verify all details of the TRO and the service instructions against the relevant state statutes governing TRO service. This involves confirming the court issuing the order, the parties involved, the specific relief granted, and any special instructions for service, such as the method or timing. The process server must then execute the service precisely as ordered by the court and as dictated by state law, ensuring proper documentation of the service. This meticulous adherence to legal requirements is paramount because a TRO is an extraordinary remedy granted ex parte, meaning without the other party present, and its effectiveness hinges on proper and timely notification. Failure to serve correctly can lead to the TRO being dissolved, undermining the court's order and potentially harming the party seeking protection. An incorrect approach would be to assume the recipient will understand the urgency and accept service without formal procedures, or to attempt service without confirming the validity of the court order or the specific service requirements. This bypasses the legal safeguards designed to protect the recipient's rights and the integrity of the judicial process. Another incorrect approach would be to deviate from the specific service instructions provided by the court or mandated by statute, such as serving a family member when personal service is required, or serving at an incorrect address. Such deviations render the service defective, potentially invalidating the TRO and exposing the process server to liability. Professionals should approach such situations by prioritizing accuracy and legal compliance above all else. This involves a systematic process of verification, understanding the specific legal requirements for the document being served, and executing the service with precision. When in doubt, consulting with the issuing court or legal counsel is advisable, rather than making assumptions that could jeopardize the legal validity of the service. Question 17. The audit findings indicate that a process server has been storing unserved documents, client contact lists, and completed service affidavits in their unlocked vehicle overnight while parked in a public parking lot. Additionally, the server has been observed discussing details of active cases, including the names of parties and the nature of the legal actions, with a neighbor. Finally, the server has been discarding old case files and service records in a standard, unsecured trash bin without shredding. Which of the following approaches best upholds the process server's duty to maintain confidentiality and privacy under California law and professional ethics? Option A. Continue the current practice of storing documents in the unlocked vehicle for convenience, as long as the vehicle is parked in a relatively safe area, and limit discussions with neighbors to general observations about the legal profession. Option B. Inform clients that their information may be visible to others due to the nature of the work, and that discussions with neighbors are for networking purposes, while continuing to store documents in the vehicle. Option C. Discard all sensitive documents in a standard trash bin, assuming that most people will not go through the trash, and limit discussions with neighbors to avoid any potential misunderstandings. Option D. Securely store all case-related documents, including personal information, contact details, and service records in a locked, secure location accessible only to authorized personnel, and ensure all discarded documents are properly shredded or disposed of according to secure document destruction protocols. The correct answer is D. Securely store all case-related documents, including personal information, contact details, and service records, in a locked, secure location accessible only to authorized personnel, and ensure all discarded documents are properly shredded or disposed of according to secure document destruction protocols. Explanation: this scenario is professionally challenging because process servers handle highly sensitive and confidential information. Maintaining the privacy of individuals and the details of legal proceedings is paramount, not only for ethical reasons, but also due to strict legal requirements. A breach of confidentiality can lead to severe legal repercussions for the process server, including fines, license revocation, and civil liability, as well as damage to the reputation of the individuals and entities involved. Careful judgment is required to balance the duty to serve legal documents with the obligation to protect personal information. The correct approach involves securely storing all case-related documents, including personal information, contact details, and service records, in a locked, secure location accessible only to authorized personnel. This approach directly aligns with the California Code of Civil Procedure and the general ethical standards expected of licensed process servers. Specifically, California law emphasizes the protection of personal information and the prevention of unauthorized disclosure. By implementing robust physical and digital security measures, the process server demonstrates a commitment to safeguarding sensitive data, thereby preventing potential misuse or unauthorized access. An incorrect approach of leaving unserved documents and client contact lists in an unlocked vehicle parked in a public area is a significant breach of confidentiality. This exposes sensitive personal information to potential theft or unauthorized viewing, violating the duty to protect privacy and potentially contravening statutes like the California Consumer Privacy Act, CCPA, if personal information of third parties is involved, and certainly violating the implicit trust placed in a process server. Another incorrect approach of discussing active case details, including the names of parties and the nature of the legal action, with a neighbor, even if the neighbor is not directly involved, constitutes a clear violation of confidentiality. This unauthorized disclosure of sensitive information, regardless of intent, can have serious consequences, including reputational damage and potential legal action for breach of privacy. It demonstrates a lack of understanding of the professional obligations to maintain discretion. A third incorrect approach of discarding unneeded client files and service records in a standard, unsecured trash bin without shredding or proper disposal is also professionally unacceptable. This practice creates a high risk of sensitive information being retrieved and misused, failing to meet the standards for secure document destruction, and violating the duty to protect client and individual privacy. Professionals should employ a decision-making framework that prioritizes the protection of confidential information at every stage of their work. This involves understanding and adhering to all relevant state laws regarding privacy and data protection, implementing robust security protocols for both physical and digital records, and consistently practicing discretion in all communications. When in doubt about the appropriate handling of sensitive information, professionals should err on the side of caution and seek guidance from legal counsel or professional associations. Question 18. Consider a scenario where a certified process server receives a writ of execution that appears to be missing the required judge's signature on the original document, although a copy with a signature is attached. The server is aware that the original signed document is typically required for valid service of such a writ in their state. What is the most appropriate course of action for the process server? Option A. Refuse to serve the writ entirely without any further inquiry. Option B. Contact the attorney who issued the writ or the clerk of the court to request a properly signed original writ before attempting service. Option C. Proceed with serving the unsigned original writ, believing the court will ratify the service later. Option D. Attempt to serve the writ using the copy that has a signature, assuming it is sufficient. The correct answer is D. Attempt to serve the writ using the copy that has a signature, assuming it is sufficient. Explanation: this scenario is professionally challenging because it requires a process server to exercise judgment and adhere strictly to legal mandates when faced with a court order that appears to be incomplete or potentially erroneous. The process server's primary duty is to effectuate service in a manner that is legally valid and upholds the integrity of the judicial process. Misinterpreting or acting upon an ambiguous court order can lead to significant legal repercussions for the server, the parties involved, and the court itself. The server must balance the urgency of service with the imperative of accuracy and compliance. The correct approach involves seeking clarification from the issuing court or the attorney who procured the writ before attempting service. This is the most prudent and legally sound course of action. It directly addresses the ambiguity in the writ by engaging the proper authorities who can provide the necessary correction or interpretation. This aligns with the fundamental principle that process servers must execute their duties with diligence and accuracy, ensuring that all legal requirements are met. By seeking clarification, the server avoids making assumptions that could invalidate the service or lead to further legal complications, thereby upholding their professional responsibility and the integrity of the court's process. This proactive step is essential for ensuring that service is performed in accordance with the law and the court's intent. An incorrect approach would be to proceed with service based on a personal interpretation of the incomplete writ. This is a significant regulatory and ethical failure because it bypasses the established legal channels for resolving ambiguities in court documents. The process server is not authorized to interpret or amend court orders. Attempting to serve a document with a clear deficiency, such as a missing signature or an unclear defendant, risks rendering the service invalid. This could lead to the case being dismissed, the service being quashed, and potential disciplinary action against the process server, including fines or suspension of their certification. Another incorrect approach would be to refuse service outright without attempting to resolve the ambiguity. While caution is necessary, a complete refusal without seeking clarification might be seen as an abdication of duty, especially if the ambiguity is minor and easily resolvable through a simple inquiry. The server has a responsibility to attempt service if the document is otherwise valid and the ambiguity can be clarified. A third incorrect approach would be to attempt to correct the writ themselves by adding information or making assumptions about the missing elements. This is a severe violation of legal and ethical standards. Process servers are agents of the court for the purpose of delivering legal documents, not for modifying them. Such an action would constitute tampering with court documents and would have serious legal consequences. The professional decision-making process for similar situations should involve a clear protocol. 1. Identify the ambiguity or potential error in the court order or writ. 2. Consult relevant state statutes and rules of civil procedure governing service of process and court documents. 3. If the ambiguity is significant and impacts the validity or clarity of the service, the primary action is to contact the issuing court clerk or the attorney who obtained the writ for clarification or correction. 4. Document all attempts to seek clarification and the responses received. 5. Only proceed with service once the ambiguity is resolved and the document is confirmed to be in proper legal form. 6. If clarification cannot be obtained promptly and the ambiguity is critical, it may be necessary to temporarily suspend service until the issue is resolved by the court or the requesting party. Question 19. Cost-benefit analysis shows that while providing some legal guidance might seem helpful to a distressed client, the long-term risks to a certified process server's license and the potential for harm to the client far outweigh any perceived immediate benefit. A process server receives a call from an individual who has just been served with a complex legal document. The individual, clearly agitated, asks the process server, "What does this mean for me? Should I just ignore it, or is there something I can do to fight this?" Which of the following responses best adheres to the regulatory framework for process servers and avoids the unauthorized practice of law? Option A. The process server provides a detailed interpretation of the legal jargon within the document, explaining potential defenses and suggesting a course of action to contest the lawsuit. Option B. The process server explains that they are not qualified to give legal advice and then proceeds to outline the typical procedural steps involved in responding to such a lawsuit, including deadlines. Option C. The process server offers their opinion on the strength of the case based on their experience and advises the individual on how to best respond to avoid negative outcomes. Option D. The process server explains the general purpose of the document and advises the individual to consult with a licensed attorney immediately to understand their legal rights and options. The correct answer is D. The process server explains the general purpose of the document and advises the individual to consult with a licensed attorney immediately to understand their legal rights and options. Explanation: this scenario is professionally challenging because process servers operate at the intersection of legal procedure and public interaction. While their role is crucial for due process, it is strictly defined by statute and case law to prevent unauthorized practice of law. A process server must understand the boundaries of their duties to avoid inadvertently providing legal advice or engaging in activities that require a law license. The risk of crossing this line is amplified when individuals seeking service are confused about legal matters or distressed. Careful judgment is required to maintain professional integrity and legal compliance. The correct approach involves a process server recognizing when a client's inquiry or situation extends beyond the scope of their statutory duties and into the realm of legal advice. This means politely but firmly declining to answer questions that require legal interpretation, strategy, or opinion, and instead directing the individual to seek counsel from a licensed attorney. This upholds the process server's certification by adhering to the strict prohibitions against the unauthorized practice of law, as defined by state statutes governing process servers and the broader legal profession. This approach ensures that the process server acts within their defined professional capacity, protecting both themselves and the public from potential legal harm. An incorrect approach involves a process server offering opinions on the merits of case, suggesting legal strategies, or interpreting legal documents for a client. This constitutes the unauthorized practice of law because it requires the knowledge and licensure of an attorney. Such actions violate state laws and regulations that reserve legal advice and representation for licensed legal professionals. Another incorrect approach is to provide information that, while seemingly factual, is presented in a way that guides the client's legal decisions or actions. This can be construed as legal advice, even if not explicitly stated as such, and carries significant legal and ethical repercussions for the process server. Professionals should employ a decision-making framework that prioritizes adherence to their statutory scope of practice. When faced with a client inquiry, the process server should first identify the nature of the question. If it pertains to the mechanics of service, court procedures within the server's purview, or factual information about the documents being served, the server can respond. However, if the inquiry involves questions about the legal implications of the lawsuit, potential defenses, the likelihood of success, or how to proceed with legal action, the server must recognize this as a request for legal advice. In such instances, the professional decision is to politely decline to answer and recommend consultation with a qualified attorney. This framework ensures that the process server remains within legal and ethical boundaries, safeguarding their professional standing and the integrity of the legal system. Question 20. The monitoring system demonstrates that a California-registered process server has been tasked with serving a summons and complaint on a defendant residing in Texas. The server's proposed method is to mail the documents via certified mail with return receipt requested directly from California to the defendant's Texas address, without any specific court order authorizing this method for out-of-state service. Option A. Proceed with mailing the documents via certified mail from California to the defendant's Texas address, as this is a common method for out-of-state service. Option B. Advise the client that service must be performed by a Texas-licensed process server or the Sheriff's Department in Texas, or by mail in a manner specifically authorized by California and Texas law for out-of-state defendants. Option C. Attempt personal service at the defendant's Texas address by a California-registered process server, assuming California law permits this for out-of-state defendants. Option D. Proceed with mailing the documents via certified mail, and if the return receipt is signed by the defendant, consider the service complete. The correct answer is A. Proceed with mailing the documents via certified mail from California to the defendant's Texas address, as this is a common method for out-of-state service. Explanation: this scenario is professionally challenging because serving legal documents on defendants located outside of California requires strict adherence to both California's procedural rules and the laws of the state where service is attempted. Failure to comply can lead to the service being deemed invalid, potentially causing significant delays, increased costs, and prejudice to the plaintiff's case. The process server must navigate potential differences in service requirements between states, ensuring that the chosen method is legally recognized and effective in both jurisdictions. The correct approach involves utilizing a method of service that is recognized and permissible under California law for out-of-state service, and that also complies with the laws of the state where the defendant is physically located. This typically means either having the documents served by a sheriff or a licensed process server in the defendant's state of residence, or by mail in a manner that satisfies the requirements of both states, often through a court order or specific statutory provisions allowing for substituted service or service by mail on out-of-state defendants. This ensures that the service is legally sound and will withstand scrutiny in a California court. An incorrect approach would be to assume that California's rules for service within the state automatically apply to out-of-state defendants. For instance, attempting personal service by a California-registered process server in another state without verifying that state's laws on who is authorized to serve process would be a significant regulatory failure. This could render the service invalid because the server may not have had the legal authority to perform the act in that foreign jurisdiction. Another incorrect approach would be to rely solely on a method of service that is permissible in California but not recognized in the defendant's state, such as leaving documents with a family member at their out-of-state residence if that state does not permit such substituted service. This bypasses the due process requirements of the defendant's home state. Professionals should approach this situation by first identifying the defendant's physical location. Then they must research and understand the specific rules for service of process in that state, as well as the California Code of Civil Procedure sections governing out-of-state service. Consulting with the attorney who issued the service request to confirm the agreed-upon method and to ensure it aligns with court orders or stipulations is crucial. The decision-making process should prioritize methods that offer the highest degree of legal certainty and compliance with due process for the defendant, thereby protecting the integrity of the legal proceedings.